Michael.
Chairman, ladies and gentlemen, first of all, sincere thanks for inviting me here today, and can I also thank this convention for all the work it's done over the last number of months and over the last couple of years. It's been a very impressive exercise, and one which the country is deeply indebted to everybody who's participated. And I want to say that because this appears to be your last evening together. I just think it should be noted that those of us who haven't been involved personally have admired what's gone on from the outside and have been pleased to see that the convention has succeeded so well. Second point is that today's session concerns a very complex problem, and some speakers have said it's not complex, it's simple. It is complex, in my opinion. It isn't easy just simply to say we vote this way or that on this issue without actually looking to what you're being asked to vote for. And although the input from the experts, which was very interesting and I'm grateful to them too, was a somewhat one-sided input, despite the best efforts of those who were participating to be objective. There are some fundamental questions which I want all of you to address this afternoon. One is, have you a clear right of what you, or a clear view of what you are being asked to say you favour being included in the Constitution? Do you know what the sum total of the set of rights that you're being asked to endorse actually is? Has anybody put in front of you even a draft text of what would be in the Constitution? Have you been told categorically whether these are soft rights or hard rights? Have you been told whether they're to be in a new Article 45 for the guidance of the Oireachtas, or whether they are, to use the lawyer's phrase, justiciable? And have you been told whether some of them should be justiciable and others not? And have you been told what the exact nature of the proposal that is being put before you actually is? And the reason I raise that question, Chairman, is this. We had a pro-life referendum in the early 1980s, and everybody thought that they were, or the great majority of people thought that they were in favour of this when it was first mooted. But when they actually got text before them, a considerable number of people said, hold it, that's not what I had in mind, and voted against it. But a majority went on with it. And the funny thing is, the majority that went on with it were the most surprised when the courts came to determine what the meaning was of what they put in the Constitution. And hands went up in horror, particularly from those who'd been most in favour of the pro-life amendment, when the Supreme Court said it means this in this circumstance. So the first lesson we have to learn is you can't be in favour of a constitutional amendment in principle in vague terms. You must look around the corners. You must say, what is being proposed exactly? What is the intention behind it? What are the intended outcomes? What are the intended advantages? And what are the unintended disadvantages? And what difference will it make in any particular case? I mean, for instance, Mary very candidly pointed to the Latvian experience in relation to old age pensions being slashed as part of their cutbacks at the behest of the IMF. But the question is, would it have made a difference, as Mary hinted it might have, in the way in which we dealt with our recent crisis? And what difference would it have made? And precisely how would it have made a difference? Would there have been some case in the High Court where a single judge decides what the Constitution means in respect of one or other of the cutbacks that were made by this government? And would somebody have said that is or is not consistent with the new article in the Constitution? And if you don't know, A, what the new article would contain, and B, how it would guide a judge as to how that judge, she or he, should decide that issue, then you are walking straight down the pro-life amendment route. And can I say another thing? Every politician that I ever heard of believes in a Housing Act. Every politician I have ever heard of believes in an Education Act, which sets out principles. Every politician I've ever heard of believes in a social welfare act, and in equality legislation, and in disability legislation, and the like. I don't know of any politician who's ever stood on any platform and said, I don't believe in this stuff. But this can be done on a statutory basis. You can say, here is the Education Act, this is what primary education now means, for instance, and say it does or does not involve free textbooks. That's an issue. The Constitution says free primary education, but an awful lot of people seem to put their hands in their pockets every year and pay for textbooks. And that seems to be lawful at the moment, because a High Court judge has not yet ruled that free primary education means free textbooks as well. But surely we should decide in Dáil Éireann whether free primary education involves free textbooks. And surely it should not be for a High Court judge to decide that issue. And if it does mean free textbooks, how many free textbooks and in what circumstances, or will a loan system of books suffice? Surely that's for politicians to decide, not for a judge in the High Court. A second point that I want to raise with you is this book, which is on everybody's table today, says at Article 6, and it's worth reading it. It says at Article 6 that all powers of government, legislative, executive, and judicial, derive under God from the people, whose right it is to designate the rulers of the state, and in final appeal to decide all questions of national policy according to the requirements of the common good. Now, either we stand by that principle that the people in final appeal, first of all, that the people have the right to say who runs the country, and secondly, in final appeal to decide all questions of policy by reference to the people's view of the common good, or we abandon that proposition for social and economic and cultural, that area, and say, no, there's to be a constitutional meaning to those things. Because as we know, this book means what the judiciary say it means. And the problem with saying, let's put stuff into the Constitution about economic, social, and cultural rights is, if you don't like the decision of the Supreme Court as to what it means, as in the pro-life decision, you end up having to go to the people with another referendum, for instance, in that case, to guarantee the right to travel when the court said it had been taken away. So you must ask yourselves at the very outset, can social, economic, and cultural matters be dealt with by legislation? And is there some peculiar advantage in putting it above legislation to the point where the legislature itself is no longer the judge of this matter, and where the people, when they're electing legislators, are no longer the judges in final appeal on the subject of what the common good is or is not? The next point I want to make to you is the obvious one, and I don't want to dwell on it too long. Resources is a real issue where direct political accountability matters. In virtually every area, from life and death decisions as to whether a patient is given life-saving drugs, and some patients are given life-saving drugs by the HSE to the value of €1 million a year, some people €250,000 a year. Those resource decisions have to be made, and the decisions to provide the resources have to come from somewhere. And the same Minister for Finance or Public Expenditure has to decide whether we spend money repairing the Abbey Theatre, for instance, or whether we double the number of people who will get a particular form of life-enhancing or life-lengthening treatment. And the question is, who decides that in a democracy? Who decides whether you give grants to Ace Donna if it means taking away money from home helps? Is it to be a judge, or is it to be somebody who is accountable to the people, who can be told at the next election, you're out, you got that wrong, you made a mistake, we don't agree with you? And that's the crucial question that we're dealing with here. Now, it has been said, and one of the curious features of the debate so far is that you are told that a growing number of countries are incorporating economic, social, and cultural rights in their constitution. Very, very few countries with our system have done it. And the reason they haven't done it is that the relationship between the state and the judiciary in our system, in England, America, Canada, New Zealand, Australia, is one where an individual High Court judge can overrule an act of the Oireachtas on constitutional grounds, can, through judicial review, direct or injunct the state from doing something, or can they can decide what the Constitution means in any particular way. That's our system. And the state is obliged to obey that High Court decision. In most civil law countries, they do not have a directly enforceable judicial review of the type we have. You cannot go into the second lowest layer in Germany and ask one individual judge to make a decision as to, for instance, cutting welfare or the like. And you can't do it in Latvia either. Our system is quite different. We give to our judiciary immense powers, but they are confined to the area of civil and political rights and constitutional rights. And this is the important point, it also extends in economic and social and cultural rights where the legislature has laid out an act which gives the judge the right to say, if that act is the law, you must comply with it. We give them that right. But we don't put it into our constitution and say that because it's not in law, the judge can decide it anyway. Now, in 1937, Eamon de Valera, a devout Catholic and a strong Republican, enacted a constitution. And those of you who have been in this convention probably have done some background reading now over the last 18 months or 2 years and realized the pressures he was under to put into the Constitution all sorts of Catholic social theory at the time based on papal encyclicals. And to give, to do really what we're being asked to do here today, to put meat into the Constitution so that the legislature would be bound to do certain things which were considered to be socially orthodox at the time and almost self-explanatory good things to do. And de Valera refused point blank to go down that road. And he said to all of the people who came up with their social policy objectives, I'll put them into Article 45, but they are exclusively for the Oireachtas to implement, and the courts will not be given power to do that. And we have, therefore, as has been conceded here fairly, we do have economic and social rights in the Constitution set out in principle form. And they are far-reaching rights. They're rights which deal with those who are with health, with the right to work. They deal with those who are economically deprived. They tell the state to control private enterprise. They tell the state to distribute resources in the community so as to achieve a just and fair outcome. Those are all there in the Constitution. But what our Constitution provides is that decision-making in that area is for democratic politicians alone. And the question is, should we end that? And as I understand, some of the submissions this morning is we could revise Article 45 and put more modern stuff into it. Fine, if you want to do that. I have no problem with that. Some of the language is archaic, and some of it is very much a creature of its time. Though I agree with Catherine Murphy that we have to be careful that when we're putting stuff into the Constitution that we don't take out the left luggage of 50 years ago, 70 years ago, and put in what will be left luggage in 70 years' time as well. But the crucial thing is this, that it isn't for want of thinking that those economic and social rights were kept off limits for the judiciary. It was because the nature of our judiciary is far more powerful than in most states. It's the same as in England, England, America, Canada, Australia, New Zealand. It is, when you have a right in Ireland, it's a hard right. And the people can expect the court's decisions to be implemented immediately. And the question that de Valera faced, and that we face now today in this context is, do we trust the democratic process? My final point, Chairman, is this. There are problems with our democracy. There are ways in which resources are misallocated. There are strongly held convictions on the part of most people, myself included, that our constitutional model in which the executive, the government, is supposed to be answerable to elected politicians is not functioning, and that the executive has far too much power. And in those circumstances, that we don't have the tradition, for instance, even in Westminster, that a government deputy can vote against the party not to bomb Syria and not be thrown out of the party and not precipitate a collapse of the government either. We have a different tradition in our Parliament of total domination by the executive of the day and rendering the opposition almost neuter in the democratic process. Things have improved a bit with the committee systems, but they haven't gone far enough. But the real question is, do we want to devalue politics? Do we trust our politicians to deal with our obligations under the UN conventions and the like, to provide the resources that are necessary, to make the decision these are the maximum amount of resources that go into health this year, and to make decisions that the culture budget will be X or Y next year? Do we trust our politicians to make those decisions for us? Or do we say, no, in certain circumstances, citizens can go to the courts and tell the politicians, you got it wrong? Well, who will tell the courts they got it wrong? Every politician faces the electorate. The whole purpose of our judiciary is that they are supposed to be immune from public opinion and to make decisions on the basis of the document in front of them without fear or favour and without trying to seek or court popularity. In my view, it is the essence of the integrity of the political process that we stand by it, however imperfect it has been, and that we don't, at this stage, seek to say that huge areas of public policy are henceforth to be determined by reference to what the judges say the Constitution means in those areas, rather than what our elected politicians think should be the correct allocation of resources. And it comes down to this. Article 6 says, as I said, that the people decide in final appeal all questions of public policy in accordance with the requirements of the common good. That right is either left with the people and their elected representatives, or it is put into the Constitution, where whatever text is put in means what the judges say it means, and nothing else. Now, finish by simply saying this. The case that has been put before you today, and I've listened to it carefully, has been vague. You have no text, you have no actual proposal, you have a bundle of rights all thrown in together, cultural, economic, and social. You don't know what's in that basket, and you're being asked to vote for it as a basket of rights. You don't know whether it's to be hard law, soft law. You don't know whether it's to be an amendment of Article 45, so that these are aspirations and policy principles for the guidance of democratically elected politicians, or whether these are to be directly justiciable, enforceable rights by the judiciary. And most of all, you don't know where the balance is going to be struck between all of those issues. And therefore, I conclude by saying this. This is a most welcome debate, but it isn't one with respect to the proponents of this particular constitutional change, which can or should be decided on the basis of a day's study of the implications when there are no concrete proposals before you. What should be done, I suggest, and I suggest you should, one of the great values of this convention is that you decide your own ballot paper. and what should be in it and what shouldn't be in it. And I suggest that you should all vote to put into the ballot paper the proposition that this area deserves further consideration, but that those who propose constitutional change must spell it out and tell us exactly what the consequences of each and every one of those changes would be. Thank you very much indeed.